The Illinois Paid Leave Law takes effect on January 1st, 2024. Employers in the state of Illinois will be required to provide employees with paid time off depending on the number of hours worked. Illinois employees will not need to give a reason for their absence as long as they give notice in accordance with reasonable employer standards. Similar laws exist in Maine and Nevada, but Illinois regulation is different because there is no limitation to the Illinois Paid Leave Law based on the size of the business. The Illinois Paid Leave Law covers all individual, public, and private employers that have one or more employees. According to the National Law Review, at its core, the Illinois Paid Leave Law provides employees up to 40 hours of paid leave annually, which employees may use for any reason. The leave accrues at the rate of 1 hour for every 40 hours worked, but employers may choose instead to front load the leave. Employers have the ability to designate a 12-month annual leave period. For example, it may be the calendar year, the employer's fiscal year, an employee's employment anniversary, or whatever 12-month period the employer designates. Whatever the leave period, employers must communicate it to the employees at the time of hire, and the employer must document in writing any changes to this period and provide it to the employees. Employees may begin taking leave 90 days after they begin employment or 90 days after the leave law is effective, whichever date is later. The law utilizes employee-friendly use provisions. The Illinois Paid Leave Law does understand that an employer may require its employees to follow company leave notice procedures, but it also places constraints. For example, employers may only require up to 7 days advance notice of the need for leave where such need is foreseeable. Employees should provide notice as soon as possible. The law also limits an employer from requiring an employee to use more than 2 hours of leave at a time. The Illinois Paid Leave Law also allows employees to use this new leave before using any other leave afforded to them, but says nothing about concurrent use of leave. Further, the Illinois Paid Leave Law does not require the employee to disclose the reason for the leave to the employer, but it also goes further. Employers may not ask for documentation or certification as proof or in support of the leave. It also stops employers from requiring an employee to find a replacement while the employee is on leave. There are a number of potential disruptions to an employer's operations, particularly because notice is limited to only 7 days and employees are allowed to use as little as 2 hours of leave at a time. The law says nothing about how employers should handle conflicting requests from multiple employees for which they cannot accommodate. Nor does it specify any information for an employer's need for blackout periods or requests that may cause other serious operational issues. The law also does not address an employer's ability to discipline an employee, nor does it address or otherwise limit an employee's ability to utilize leave under false pretenses. Employers adopting an accrual-based leave policy must permit employees to carry over unused leave year over year, but they can cap leave use at 40 hours annually. Employers using the front load method need not permit any carryover. At year's end, employers need not pay out the employee for any unused leave. Likewise, employers need not pay out unused leave at separation. However, employers who credit leave under this law to another paid time off or vacation account are required to pay out such unused time consistent with Illinois' wage and hour law. The law has several notice postings and record-keeping requirements. Employers who already maintain leave policies need only review and, as necessary, conform those policies to ensure they meet the law's minimum requirements. Employers without such policies will have to implement new ones. The Illinois Paid Leave Law imposes a record-keeping obligation which requires employers to preserve records that show hours worked, leave accrued, leave taken, and the remaining balance of available leave for 3 years. Employers must make these records available to the Illinois Department of Labor upon request. Employers must also post a notice describing the law's requirements and procedures for filing a charge. The Illinois Department of Labor will prepare and publish this notice. The Illinois Department of Labor is responsible for the law's administration and enforcement. There is no private right of action. Employers who violate the law are subject to damages, including compensatory damages, attorney's fees and costs, a civil penalty of up to $1,000 per employee paid to each affected employee, a civil penalty of $2,500 per violation paid to the Illinois Department of Labor, and equitable relief. If an employer fails to post the required notice, the law imposes a penalty of $500 for the first violation and $1,000 for any subsequent violations. The law covers most employees, although several exceptions apply. The Illinois Paid Leave Act covers all employees in the state and shall include any individual permitted to work by an employer in an occupation, but it does contain specific exceptions, some of which include certain unionized workers, certain federal and state employers, and employers subject to the Cook County or Chicago paid sick leave ordinances. Further guidance will also need to be issued in the remote work context to understand when an employee is considered working in the state of Illinois. The Illinois Paid Leave Act still has a number of unanswered questions. I suggest Illinois employers or those employees who live in Illinois begin reviewing its record-keeping practices and stay abreast of the latest changes related to this new law. That again takes effect January 1st, 2024. For more information, visit the Illinois Department of Labor's website.